Welcome to the Stratford IP Strategy Academy. In this session, you're going to learn about patentability searches and how to incorporate and leverage them when building your IP strategy. Let's get started. Let's imagine for a moment that you've just come up with a great idea and you've decided you would like to apply for a utility patent. Where do you start? Since patent applications are evaluated and granted on the basis of being novel and non-obvious, it's a good idea to begin with a patentability search. Doing so will allow you to check if someone else had already thought of your idea, and determine what scope of protection you might be able to get before you invest your time and money into applying for the patent. To determine if an idea is patentable, an examiner will compare it to what is considered state-of-the-art, as described by known prior art. Prior art is not limited to issued patents or pending patent applications. It is considered to be any existing evidence that your invention is already known, such as publications, anything found on the internet, or within the public domain, whether scientific or not. Essentially, any information that was available prior to the filing of a patent application can be considered prior art. You have a duty to disclose any prior art that is uncovered during your search. Depending on your situation, you may wish to start by doing a bit of digging yourself. If you are searching on behalf of an employer, be sure to find out your company's policy on IP searching before getting started. There are several public resources available that will likely yield a high level of understanding of what is available that is comparable to your idea. You should start by searching Google Patents or the European Patent Office's Espacenet database. If your search yields results that you think are very relevant, reach out to your patent agent to discuss what scope of protection might still be available. It's important to discuss any findings verbally, as writing down any opinions about IP validity or infringement can be dangerous. Claim language can be hard to interpret unless you have expertise in patent law, so in the event that you misinterpret the language, you're opening yourself up to a great deal of risk by writing it down. You wouldn't want your misunderstanding to be used against you in the event of litigation. It's best to let subject matter experts do the evaluation, instead of making uninformed opinions yourself. Can't find anything? Everybody can search, but not everyone has the same tools to do so. Different search engines apply different personalization algorithms which tailor the results you see. It's quite possible that even after searching, you may be missing relevant prior art. This is where a patent information professional can come in handy. The advantages are twofold. Not only do patent information professionals have the experience and skill to search for prior art using all the tips and tricks that are available, they also have access to specialized databases. For example, by using specialized patent database tools, the professional can create very specific search parameters to extract relevant documents using structured query language. This can leverage both keywords and patent classification searching. Searching using non-personalized algorithms is also possible. Be prepared that the searching may require iterative rounds, as the boundaries of the prior art and innovative concept both become more defined. When deciding to work with a patent professional, there are two things to consider to ensure good fit and solid ROI. First, evaluate their searching capacity. Do this by inquiring how the professional was trained on IP searching and what tools they have at their disposal. If they respond with the same public resources you have already utilized, they likely won't add much. Second, communication is key. Make sure that you have the opportunity to speak with the analyst directly and that they understand the invention and the industry it's part of. If you can, you want to avoid a scenario where having too many people involved results in a broken telephone situation, muddling the quality of your results. The objective of a patentability search is that the results should allow you to move forward, or decide not to move forward, with a better understanding of the field. This could include discovering potential new competitors or expired technology you were not aware of, and to come away with an understanding of the border of the prior art and your innovative concept. Pragmatically, it is not a good use of resources to spend the time to find and evaluate every single document that could be relevant to the application. Except for some high-value strategic cases, there is usually a diminishing return on investment regarding value obtained the longer you search. Finally, the 18-month publication lag for patent applications means that the risk can never be completely removed. Despite these constraints, there is still enormous benefit to searching before filing. Once there is a better understanding of the field and where opportunities lie, the inventors and patent agent refine the invention to its fundamental, innovative concepts. This becomes the foundation for the claims of the patent draft. During prosecution, the patent examiner will search what is known in the state of the art for the claimed scope. The objective is to allow a patent with valid scope coverage. Given the large breadth of prior art in every field, you will receive more citations when the examiner performs their own search. Each patent office reports cited art in a different way, and different times throughout the prosecution. WIPO and EPO provide a search report before examination begins to help applicants decide how they want to move forward with their application. The USPTO provides applicants with cited art during examination through office actions. Based on a patent's requirements for being novel and non-obvious, the Patent Office will categorize their findings. Most often seen in WIPO's and EPO's search reports are X, relevant for novelty, Y, relevant for inventiveness, and A, general state of the art. The USPTO uses classifications for the rejections issued in office actions. A 102 rejection relates to the invention being anticipated, not novel, while 103 rejections relate to the obviousness of the invention, which is how the USPTO deals with inventiveness. Even if you receive an X or a 102 rejection, don't be disheartened right away. Work with your patent agent to navigate the best way forward. Performing a patentability search is a useful step to help inventors and companies make better decisions about what to do with an innovative idea. By doing so early in the process, a patentability search allows you to understand the opportunity and risk in a field by exposing potential new competitors or expired technology you are not aware of. It should help you tailor a strategy on how best to move forward or decide not to. Remember, effective communication with your chosen patent professional is key. Without good input, the search results won't be worth your while. And finally, search reports provided by examiners can provide further information to help navigate the examination process.